Good morning, everybody. I'm going to ask all our participants to mute. My name is Elena Pop. I am the Executive Director of the Eviction Defense Network. This is our presentation on the eviction process. What we cover in this presentation is the eviction process from beginning to end, and we also talk in depth about the 16 factors that a tenant and or their lawyer needs to consider in deciding whether or not to take a settlement deal or fight to save the unit. An eviction is a lawsuit. The other day I asked, the question that was asked of my client is, have you ever been in a lawsuit? They said no. Well, they're in this lawsuit. So the answer is yes. An eviction is a lawsuit. And the process of eviction is called litigation. And there is a lot that goes into litigation. The eviction process starts with a notice. It can be any length of days. 3, 15, 30, 60, 120, anything in between. It can be longer. To do something or quit. Another way of saying quit, which means leave, is vacate. Another way is terminate tenancy. But if you read the notice, the message is you have 3 days to do something, and if you don't do it, you have to leave. Or it could just be a quit notice, like 3 days to quit because you've done something so horrible that there's no reason to give you an opportunity to cure it or to fix it. And so you have to go in 3 days. Or it could be a 30 or a 60-day notice to quit, no reason given at all because you don't have any protections under the law. If you don't do what that notice says in that number of days, legally, the only thing the landlord can do is file a complaint for eviction. The complaint is the paper that tells the court what the landlord's beef against you is. What is it that they are alleging or saying that you're doing wrong? And the court then issues a summons. And the summons is the paper that gives the court power over you to come into court. It gives the court power over the parties to issue orders. Now, during the pandemic, we've seen a marked increase, 75% increase in landlords not bothering to do this. They just come with a truck and they kick you out. And sometimes they just come with a couple of big guys and just kick you out, or they just come, you come home from work and you are locked out. That is illegal, but it is happening. And I have people get upset with me all the time. Well, if it's illegal, why is it happening? Well, it's illegal to kill people and it happens every day, right? Just because something is illegal doesn't mean it doesn't happen. And unfortunately, prosecutors don't enforce against it. The police don't do anything about it. And we don't have enough lawyers to file all these cases. So I have tons of people who have already been illegally locked out and no place to send them. So we have to be aware of that, but legally, they're supposed to go through this process. If you do nothing, then you're going to end up with a default judgment and a notice to vacate, and then the sheriff is going to lock you out. The number of days between a default judgment and the sheriff actually locking you out pre-pandemic ranged between 14 and 21 in most cases. During the pandemic, we are finding that it takes a lot longer to get from default judgment to notice to vacate because there's been so many changes in procedures that the lawyers and the landlords make mistakes and have a hard time getting the paper that they need to take to the sheriff, which is called a writ of execution. They have a hard time getting that paper. But we're also finding that the amount of time that it takes from when the sheriff gets the writ of execution to a actual lockout has gotten much shorter. So it used to take about 7 days for this, and then 14 days for this. Now we're finding it's kind of reversed, and but it's more once you have that final 5 day notice to vacate, which I'm going to show you a picture of. The sheriff does tend to come out day 7 or 8, and sometimes even day 6. So we have to it doesn't give us a lot of time. If you end up down this road, it doesn't give us a lot of time. And like I told one of you who has one of these notices, I have four to figure out what to do with this weekend. All of them expiring Monday and Tuesday. Some of them we've already given notice that we're going in on Monday or Tuesday. And so there aren't enough resources to help everyone that needs help at this stage. You need to go on this route, which is filing an answer. It's due 5 working days after you are handed the summons and complaint package. The summons and complaint package includes the summons, which I'm going to show you, the complaint, which I'm going to show you, and bunches of other documents. And those documents, 25, 30 pages, are supposed to be handed to you. Now, for a reason that I'm going to explain in a minute, process servers don't usually, if you're not home, they'll drop it on the door. And then you find it on the door. And our recommendation is to just file it, file the answer, not worry about the fact that they didn't hand it to you. And I'll explain to you why in a minute. After the answer is filed, there's a whole bunch of stuff that happens here if you have a lawyer. Discovery and all kinds of other preparation in order to be prepared for this trial date. We'll get the trial date and we'll show up, and very rarely does a case just go straight to trial because we demand a jury. And in order to do a case in front of a jury, there's a lot of preparation that has to happen because you have to prepare documents that explain the law to the jury. So there's a lot of negotiation that has to happen between the two lawyers and then between the two lawyers and the judge before this case is ready to go. Eventually, there is a trial and a judgment. And if you lose, you go back on this track to the sheriff. And if you win, then you get to stay in possession. A couple of points. In here, there's a lot of potential for negotiation. And in the next diagram, we show how at every stage of the game, there is a possibility to settle the case. Other point that I want to make is, see how tiny this little box is? Tenant remains in possession. Tenants often want justice from this process, and that's the last thing you're going to get from this process. People want to tell their story. They want to talk about how evil the landlord has been to them, about all of the lies the landlord has told, about the fraud they perpetrated. They want to talk about the overall injustice of the entire tenancy. And this process doesn't allow for that. In this process, if you are the winner, what you get is the right to stay. You're not going to get money out of it. The judge doesn't have power to issue a judgment for money. If you want a judgment for money, if you want them to stop doing a particular behavior, you have to get a restraining order in order to make that happen, or file a separate lawsuit. This is the same process. I want to start by making the point that the eviction process is very long, and with a lawyer, we see 98% of the time success. It's not a guarantee. The best case can be lost. The worst case can be won. I've recently told a young lawyer on my team, there's no way to win that, Natalie. How are you going to win that, Natalie? But she is quite brilliant, and she's proven me wrong twice in about 2 months. And for a lot of reasons, including that she has a very good style with the jury and was able to convince juries in 2 cases that the behavior that the tenant had done did not amount to a nuisance. So the worst case can be won and the best case can be lost. We measure winning as either success, meaning we measure success as either winning and you get to stay, or a settlement on favorable terms. And we see that 98% of the time. So again, the eviction process starts with a notice and then the summons and complaint for unlawful detainer, which really just means eviction. And the accusation is that you are unlawfully detaining the unit. The courtesy notice comes from the court. The landlord's supposed to hand you the summons and complaint, but they often don't. So the court warns you about the lawsuit, and this could come before or it could come after. It's mailed within a day or two of the filing. So sometimes the courtesy notice, which comes in the mail and it's just a couple of pages, beats the 20 to 30 page packet, and sometimes it comes afterwards. Once you have the summons and complaint, you have 5 working days to answer. Our recommendation is that if you get a courtesy notice, wait a day or two to see if they bring it to you, but then let's not get into a pissing match with a registered process server about whether or not they handed it to you. Let's go to the court, get a copy of the file, and let's get that answer done. Because often they do lie, and if they lie, the judge is more likely to believe the registered process server than you. 5 days to answer. After the answer is filed, both sides usually propound what's called discovery, meaning questions and demands for production of documents and evidence. Because in our legal system, both sides are allowed to know exactly what evidence the other has against them so that they can prepare and make appropriate decisions. So we're not a system about sandbagging. On TV, you often see this surprise piece of evidence. Usually, if you have a surprise piece of evidence, the judge will not let it in because you should have disclosed it ahead of time. At some point, the landlord will request a trial date, and then comes the notice of the trial. The trial is supposed to be held within 20 days. The reality is that the courts are very, very backed up. They were already backed up pre-pandemic because we have increased representation. When you don't have a lawyer, 49% of the cases get resolved with a clerk saying, oh, no answer filed, therefore tenant loses automatically. And of the 51 or so percent that actually file an answer, a good many of them don't show up to court at all and lose on what's called a prove up hearing. And of the ones that show up to court after a 10 to 20-minute trial, the tenant loses. 98% of tenants that go to court alone, 99% of tenants that go to court alone lose. 98% of tenants that have a lawyer have success. So without a lawyer, it's like this 10 to 20-minute process. There's a lawyer who used to be a judge who used to be downtown. I won't say her name out loud. Is now in Santa Monica, who boasted to a group of AmeriCorps volunteers that she can do a eviction trial in 10 minutes. That's nothing to be proud of. You cannot give a tenant justice in 10 minutes. But it speeds things up now, doesn't it? It makes the system efficient. With a lawyer, a jury trial takes minimum 5 days, a day or two to select a jury and 3 days for the trial. So the result is that the system is bottled up. We don't demand juries to bottle up the system. We demand juries because that's where we get a fair shake. I started demanding juries when I lost a case that should not have been lost. My client, and I like to tell stories during this because I think it gives it context. So my client, long-term tenant, very low rent, rent controlled. His bank made a mistake and bounced a check and sent him a letter with a replacement cashier's check made to his landlord. That same night that he'd gotten that letter, he hadn't even had a chance to do anything about it. The landlord knocks on the door with a 3-day notice to pay rent or quit. Oh, yes, I'm sorry. My bank made a mistake. I have a replacement cashier's check. The landlord rejects it. The tenant, the very next day, sends it certified mail to the landlord. I frankly, by the time this happened, I was already a little distrustful of most judges, but I actually picked up this case in court the morning of court because the bailiff thought the client guy was going to have a heart attack. He was so upset. And so she asked me to help him. And so I looked at his paper and was, oh, this is easy. We'll just win it. And so the judge believes the landlord that the tenant never tried to give it to him that night. Like, why wouldn't he give it to him? And that the envelope was empty. And that day I vowed never to do another trial in front of a judge. Now, that's not really true. There are some judges that are fair, and so if we get assigned to one of those judges, we sometimes will waive the jury. But for the most part, we want um, to have the case decided by people that are like you. Most judges have never been tenants, except possibly when mommy and daddy paid the rent while they were in college. Most judges tend to come from affluent families. And so we want people who can relate to you to be deciding the future of your tenancy. And so that is why we demand a jury in every case. So this, as a result, though, we were already about 8 months behind in getting cases to trial. Both sides of the bar have very high caseloads. Landlords are not going to pay huge amounts of money to evict tenants. And so most of the firms that do this, that evict tenants, carry very, very high caseload. So each lawyer is coming into court with 3 or 4 or 5 cases on any given morning. And all of the law firms, and especially the Eviction Defense Network, carry very high caseloads at all. And so, as a result, sometimes we need a continuance, sometimes they need a continuance, and sometimes both lawyers are ready to go, but there's no judge available because there's only 33 trial judges in the system. And so there is a lot of delay. And during the pandemic, there was even more delay because we weren't doing jury trials because it's impossible to socially distance one. During the pandemic, I think we did maybe 3 or 4 jury trials. Now they are getting sent out again, but it causes a great deal of delay. So this 20 days has been sort of, it no longer really applies. What ends up happening is we keep coming back, we keep coming back, we keep coming back. That makes tenants anxious, even though it really shouldn't. The extra time benefits you in many ways, including giving us more time to prepare and also making sure that, and also kind of serves to get the landlord to listen to reasonable offers, right? So we've had a lot of cases during the pandemic where for months and months and months, I don't want the rent, I want the tenant out, I want the tenant out, I want the tenant out, but so much money has built up that it's now worth it for them to accept the rent and or the rental assistance, and we end up getting a settlement with the tenant staying. Throughout this process, there is an opportunity to negotiate throughout the whole process, including after losing. We have made very good deals after we've lost a case because the threat of appeal is also something that the landlord does not want. Uh, this route here, this route here is the if you do nothing, ending up with a sheriff locking you out. There is a motion that we can do, which is the people that are here with notices to vacate. We have to see whether or not we can do anything to get you back up here. So if you received the documents, if you get served the summons and complaint and you do nothing about it, the judges are not very sympathetic about that. Theoretically, there is a process under Civil Code Section 473 where you can go into court and say, sorry, I was confused, I didn't know. The media says there's a pandemic and I thought I didn't have to do anything about it. I got, you know, the landlord misled me. There's all kind, except that it's really hard to win those. We can also go on in and say, hey, I never got it personally. Those are easier to win, except you have to prove you were someplace else when the process server says they handed you the papers. And then if the reason you're here is because you've already lost your case at trial, we can do motions to either, if there's something on the face of the paperwork that says you shouldn't have lost at trial, we can do a motion for reconsideration. Or if there is a hardship that is more than most tenants. Example, you live in a below market rate unit that is protected by a rent stabilization law. We can sometimes let the judge let you stay if you have the rent. And under the pandemic rules, if you've been approved for rental assistance, that's also a way to get you back into the game, to not have you be evicted. In this little box is tenant files motions. You notice 5 days to file an answer. There are 3 motions that you can do to delay filing the answer. One is the motion to quash. If the landlord did not have someone hand you the papers in your hand, you can do this motion to quash. All it does is force the landlord to do the process right. Takes time to do this, usually delays the process about 10 days, and then you get the stuff in your hand and then you're back on this. So motion to quash, you're back here, here. So it creates this 10-day delay that, frankly, in my opinion, costs our scarce resources more than it's worth. So many years ago, in like the early 90s, I convinced all of the agencies in our system not to do motions to quash. In the 90s, we were serving approximately, less than 2% of the need of tenants facing eviction. The number of evictions filings were upwards of 73,000 families being evicted in LA County. We were representing in the 700 range and wasting time on motions to quash. And I figured out that the amount of time that it took us to do 4 motions to quash, we could represent one whole other family. So I convinced people to stop doing this. One of the consequences is more inappropriate service. So process servers know that if they just dump the papers at your door, if you get to one of us, we're just going to tell you, let's file an answer. They don't have to keep coming back to serve you. And so we get inappropriate service, but I still think it's worth um, being able to represent more people. Another motion is called a motion to strike or a demur. Basically, those motions say the paperwork's not filled out right. They haven't raised their claims correctly, or they don't have enough detail in the facts. The only thing that results in is the judge gives them a time to fix the problem. So it creates, again, this little loop that you end up back here anyways. And again, I don't think it's worth doing it. So we don't do it. In my career, I have done 3 motions to quash, and all 3 of them, if the motion were granted, it gets rid of the whole case because the tenant had already moved out. And I've done 1 or 2, I think 2 demurs. Actually, I only remember 1, but I must have done at least 2 demurs. And the one that I remember, the tenant never got a notice and complaint. And so there was no reason there was no there was no way for us to tell what defense to raise, and so we had to do a demur so we could find out what the case was about. But again, we don't really do them, and I do spend an inordinate amount of time arguing with people about why we don't do them. And again, sometimes we send out an offer. If you have a place to go already, you know you're moving to your new job in Utah. I had that case. And you're moving in 4 months and it's foolproof, then we can make an offer with the answer, propound discovery, and a jury demand early in the game and get the case settled early. A lot harder to do during the pandemic. During the pandemic, and this is where I want people to really listen really carefully, especially those of you that are in eviction proceedings and want to move out. A lot of people come to us and they're done. They want to move out. We want you to think about what you're giving up. What's the value of your unit? Is a unit protected by a rent stabilization law? If it is, do you really want to give that up? And if you do you have a plan? Okay. So if you don't know where you're going, then we tend not to let you make the mistake of making a deal too early. Why? I've gotten people 6 months to move, and then 10 days before that 6 months are up, they're back saying, haven't been able to find something. So we tend to persuade you not to make a deal unless you know for sure that you're going to be able to get out because you've already got a plan, and you have a plan if that plan fails, like you have a couch surfing opportunity in case that plan fails. So during the pandemic, that's our policy to start with, and it's been our very strict policy during the pandemic. Pre-pandemic, I had this woman who was paying very, very low rent in a rent-controlled unit, but she had really had it with the harassment. And I'll talk a little bit about harassment and how difficult it is to stop landlords from harassing you. And again, the 1 o'clock presentation has more on that. And then we are going to, at some point, do a recording of the longer presentation for stopping harassment so people can. I can't find any more time to do any more presentations. So I want people to be able to have access to a recording of that longer anti-harassment webinar. But it's very, very hard to get landlords to stop harassing tenants. She was done. She was tired. She couldn't do it anymore. And every time we'd go to court, she'd want me to make a deal, but there was no way she could replace her housing. And one day she tells me, but I really, really want to move. And I said, and I really, really want to be 35 and 105 pounds again. We don't always get what we want. Find a place to go and then we'll make a deal. Well, eventually her sister bought a house. Her sister, she was able to move in and we were able to get her a substantial amount of money to be able to give up that below market rent unit, right? But we really have to look at whether you have a plan. I have a client right now who insists that he'd rather be homeless than continue living in a house where the landlord, it's a boarding house, so he lives in the same house as the landlord, and he wants a move out deal. What I keep telling him is there's no way for us to lose this case, so we're not making that deal. If you want to move out, move out, but we're not making that deal because you have no place to go. And so far he's still staying there because he doesn't really want to be homeless. It's not better to be homeless than to be in that house. So during the pandemic, we've been very, very strict about not making move out deals unless someone has a real plan. Um, Moving on to the next slide. When you first come to us, we ask you to fill out a questionnaire and you give us all of the information about the tenancy. And then we ask you to choose a path. The path to the left is the save the unit path. I want to stay. I want to protect my housing. I recognize the value of my housing. I recognize that activists before me fought for laws to protect me. I am going to honor that and I am going to fight to stay. The road to the right is I want to move out. I need enough time, enough saved rent, maybe some extra money and a clean record, and I'm out of here. I don't care about saving the unit and this isn't such a great deal anyway, so I'm happy to put you on this path if you're paying market rent, or if you can't afford your unit, or if the situation is really bad and you have a plan. So how much time do you need? How much rent are you going to save? Are we demanding any extra money on top of that? If so, how much? And how much we can demand depends on these 16 factors that I'm going to cover in a minute. And then finally, a clean record. Okay. So you choose a path. And then with your lawyer, we're going to discuss whether that path is reasonable. So sometimes tenants are afraid and disempowered and don't realize that they don't have to move out. And so we move them from this path to this path if they have a strong case and reasons to fight. And sometimes tenants are like, there's no way of winning this case. You don't have any rights, but you want to be on this path, and we gently move you from this path to this path. Once we've put you on the correct path, if you want to go for this path to this path and there's a way of winning, we will put you in a four-wheel drive vehicle and we'll take you right here because we're all about saving housing. Saving housing stops gentrification. Gentrification is the loss of affordable housing in low-income communities as people with more ability to pay higher rents come in and displace people who are lower income. We are in the middle of a housing crisis that started in May of 2016. How do I know it started in May of 2016? Because at Eden, we ask all our clients, regardless of what path you are on, to look for housing. Why? because we want you to have that choice if it comes to that, right? So look for housing, and then we kind of keep track of what people are finding out there, and we used to be really really good at it, much more diligent about it. So between May of 2016 and September of 2016, the average cost of a single in Pico Union went from 800 to $1,100. And then by February of 2017, it was $1,300. And the reason I realized that is that prior to the fall of 2016, 98% of our cases, 99% of our cases settled with a move out. Why? You're already in a problem with your landlord. You're paying X amount of rent. You've only been there a year or two. Market value is just a little bit more than what you're paying. You haven't paid rent for 2 or 3 months already. I can get you another 2 months. You can use that money to move out. Why not take a deal? Most tenants were happy to move. Most landlords were happy to have them move. And so most cases settled. In September of 2016, I realized that 87% of our cases were going to trial. Why? The tenant couldn't find anything. They were looking like we instructed, but they couldn't find any place to go that they could afford because prices had skyrocketed. And the landlord was much more motivated to get that tenant out because they could get that much more. And why do rents go up? Because they can, because we don't have any vacancy control laws, meaning even where there is rent stabilization or rent control, which really that we don't have rent control anywhere in California anymore because we don't have vacancy control. If you want to know why, come to the 1 o'clock webinar. We don't have vacancy control. We have rent stabilization. So if the landlord gets you out, either by accusing you falsely of something or harassing you until you move out or any other reason, the rent can go up to market. And so there's a lot of incentive to harass. That's why there's so much harassment. And so that's why the rents are so high. So a lot of you will, when you're telling me your case, will talk to me about it's not that I did anything wrong. It's that the landlord just wants me to move out because they want to raise the rent to market. Da, da, da. You don't I don't need all of the details of that. I know that. I probably know it better than any of you because I talk to 10 or 20 people a day that are experiencing that. When I was a young lawyer, I would go to court and I would tell the judge, Your Honor, my client is a below market rate rent control tenant. The landlord has been trying to get them out. This is the fourth lawsuit that the landlord has filed. The tenant won in the first three. And then on the fourth, people always find a way to screw up. So now we don't have a defense because the tenant screwed up or was lax about something. And now we're in a, and so I'm trying to argue it's not fair that the landlord kept trying to trick them and finally did. And the judge said to me one day, Miss Pop, I don't know why you argue that. Of course, the landlord's trying to trick your client into making a mistake. The landlord is a capitalist country. It's all about money. If the landlord can get your tenant out because your tenant sat on their rights, then why shouldn't they be able to get your tenant out? And that is the reality that we are living with. This is another example of why I prefer to have a jury rather than a judge, because that judge is going to look at the little narrow box of the law and say, yeah, that tenant didn't. Like a good example of this is a tenant that was paying something like $1,000 a month for a 3-bedroom unit in Santa Monica. The landlord kept trying to evict her. So they did a hoarding case, we won. They did a non-payment rent case, we won. And then the tenant gets a 3-day notice to pay rent or quit. And she says, oh, here he is again, trying to harass me. I already paid my rent. Does nothing about it. Doesn't realize her check had bounced. Well, in case 2, the landlord made all the repairs. And in case 3, they made not a single mistake. The 3-day notice demanded exactly what she owed. They did all of the stuff they had to do with rent control board correctly. There was not a single thing wrong with the apartment because they had already uh, dealt with the um, dealt with the breach of warranty of habitability. And so the place was perfect. There were no defenses. So don't let that happen to you. It happens more often than it really should. And she ignored that 3-day notice because she thought it was bullshit that the landlord was trying to, when she'd already paid her rent. Okay. Um, so, um, so be very aware of all of this in making your decision. So again, when you come to us, we ask you to pick a path. We make sure that the path is reasonable. If you're a below market rent tenant with a winnable case, we do our best to continue, persuade you to be on this path of staying to save the unit, unless you really, really want to go and you have a plan, in which case we'll try to get you a lot of money to make that happen. If you don't have protections or can't win the case, then we're okay with you being on this path, but we want to make sure that you have a plan and that we don't settle the case in any way that will result in you being homeless. Um, Sometimes, we have a lot of cases, and a client will want to move out, and my staff person is like tired of arguing with them about why they have to have a plan. And I will say, um, we do not settle people into homelessness. Now, I settled someone into homelessness this past week. It's a case we cannot win. The tenant is not cooperating, and she says she wants to leave in 60 days. But in 60 days, she's not going to be able to find another place to go. In a year, she won't be able to find another place to go because of the particular circumstances, and the rent is so low. So I've been moving forward to knowing we're going to lose and thinking that because she is older and has some disabilities, that we would be able to then convince the landlord, the judge, to let her stay as a hardship as long as she takes care of the problems with the unit. She's refusing fumigation when there are roaches and bed bugs. So we have to get her to cooperate. So we're having a final meeting with the judge, and I have her on my phone, and I'm appearing remotely, and she starts yelling at me. I told you I don't want to go to trial. I told you I just want 60 days. You're not listening to me. And so I ended up negotiating end of January, which is much more than 60 days. But I know that she is not going to have a place to go at the end of January. And she has a Section 8 voucher, but the housing authority has already told me that they're not going to issue her a new one because they think that she is at fault here. And so they're not going to give her a new voucher. And I've told her that the only way for her not to have to move into either a shelter or a boarding care facility is for her to move forward to trial, probably lose. We'd draw on a judge that would probably have done a hardship motion as long as she cooperates, but she doesn't want to cooperate with fumigation because she doesn't think she has a hoarding or a bed bug or a roach problem. So there are, lots of factors went into that, and we got her the best possible deal. The main lesson from that is listen to your lawyer, especially if your lawyer has been doing this since 1981 as a law student, 1985 as a lawyer, and is about as zealous as a lawyer should be about pushing the envelopes of the law without risking a real loss. So I'm going to move on to the next slide, and the next slide is about the 16 factors to consider in a um, in deciding how to resolve the case. Okay, so the first thing we look at is the value of the unit. How much rent are you paying for how much space? With what amenities in what area of town? Are you below market? The next thing we look at is the unit protected? Protected by what? The most common protection is rent, what we call rent control, but is really rent stabilization. A rent control law is a law that protects the unit and the value of the unit. So no matter who's living there, the maximum allowable rent stays the same The new tenant moves in, no matter the reason that the old tenant got kicked out, the rent stays the same. In a rent stabilized unit, when the tenant moves out, the new tenant pays market rent, whatever the landlord wants to charge. And so that's why it's called stabilization. Since 1996, we have not had any rent control laws in California because of a law called Costa-Hawkins that we have tried to take off the books twice in 2018 and again in 2020, and we have lost both times. Why? Because vacancy decontrol is the holy grail for landlords. It's the thing they care about the most. And so we have no rent control, we have rent stabilization in California. Um, but if you have a rent stabilization law, hold on, Kevin, you don't have to cut this part out. I'm just going to stop until they're done. We have a park across the street, and they think the park belongs to them. So anytime someone goes into the park, they start barking. And we have a movie crew that's been out there for the last 4 days filming a show called Snowfall. And so that's why they're being so disruptive. Okay, so rent stabilization, rent control is one way to get protection for the unit. Another way a unit can be protected is if you have a federal subsidy. So a Section 8 voucher, a if you live in public housing or subsidized housing, there are rules that restrict the landlord's ability to evict you, and so that is protection we look at. And then a lease. Very rarely, but every once in a while, we find someone with an unexpired lease. Now, I can tell you up front that the judge is going to be suspicious of that lease if it is more than a year, because it is rare for landlords to want to obligate themselves to rent to a tenant for more than a year in a residential context. Commercial tenancies, yes, long leases, because people are putting in a huge investment to start a business, and displacement of a business is very, very costly. But for residential, typical lease 6 months, less typical 1 year. And anything more than that, if the landlord says that it's a fraud, then the judge is going to believe it's a fraud unless you have a handwriting expert that can prove that it is the landlord's signature. But if there is a lease that hasn't expired, that lease provides protection. The lease also encumbers the tenant. And so even if the lease is expired, and every time you pay the rent, you renew it for another month. And so we need to see the lease to see if there's anything in it that's either going to help or hurt the case. The next thing we consider is, can we win? Number one, does the law support us? Is there a defense? Number two, do we have the evidence to prove that defense? A good example is the tenant says, oh no, it's a 3-day notice to pay rent or quit. The tenant says, oh no, I paid all that rent. Okay, where's your receipts? I don't get receipts. How did you pay? In cash. There we have a good defense, but are we going to be able to prove it? We have had cases where the landlord has claimed that someone has lived there for free for X number of years, and the jury has believed the tenant, that the landlord just refused to give a receipt. But generally, if you don't have receipts, that is not going to be a good case. Another element of can we win is, how good are our witnesses, especially the client? Can our client follow instructions? One of the if you look at my Yelp reviews, a lot of my clients end up not liking me because I'm a tough taskmaster, right? First of all, I don't want you displaced. And secondly, I have a reputation to uphold. And if you're not listening to what I'm saying and want to do things your way, you hurt yourself, and you also hurt other tenants in the future, because my reputation is affected by that. And I get a lot of stuff out of the other side because of my reputation, because of how I've handled cases in the past. So if you need to listen to what I am saying, and tenants have a tendency to talk about their case, and they're either angry, whiny, or indignant. And those are very unattractive ways of being. okay? If you are barking the facts of your case and talking in this tone when you're talking about your situation, can you see how unpleasant that is? And it is unpleasant to me when I'm trying to prepare your case and counsel you. It wears on the nerves, especially if I spent the entire day talking to people who are yelling at me and barking at me when exactly the same thing can be said with this tone. This is a very pleasant tone. And this is not my natural tone. People that know me know that I'm usually a little bit more pressed and agitated sounding, kind of like this when I'm counseling people. Also unpleasant. And I honestly try to control it, but usually by 8 o'clock at night, it's harder to control. But this tone is way easier to listen to. And you can be emphatic. See, I can sound emphatic without sounding angry and without sounding whiny and without sounding indignant. Okay. It's harder for me to do the whiny tone because I'm not by nature a whiny person. But the nya, 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 and then they did this and nya, 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 unpleasant. It is very, very unpleasant. And the jury will not like you if you testify with that tone. And then and then they did this, and then they did that, and then they did the other. That tone, also unpleasant. We're looking for this spokesmodel tone, or what I call my Disneyland princess tone. Very, very level tone. Okay. We also need you dressed in a professional manner. People show up to court in t-shirts and sweats and all manner jeans, and not okay. It shows a level of disrespect that the judge and the jury will catch on to, will notice, will um, judge you for. Juries are just notorious. I'm going to give you two examples of jurors that judged me. I try to get my hair done before I start a jury trial. Why? Because I once had a juror do a anonymous comment sheet about how uh, I seemed to be a great lawyer, but why was her hair such a mess? And I hadn't had a chance to get my hair done, so I had it up in a bun the whole time. But you could see where the natural color my hair should have been started, and so she was bothered by that. Okay, I had another case where I ripped my nylons on the way to court, and I had another pair of nylons because I always carry an extra pair in my pulley, but I needed to be able to put them on. And I was early enough so the juror shouldn't have been there. But I swear to God, I get off the elevator. And, this is when I was younger and my skirts were shorter. These three female jurors look at me up and down, and they get this very judgmental look on their face about the fact that my legs were bare. I go inside the courtroom. I commented to the clerk about it, and she lets me go in the jury room so I can, not so I can put my nylons on. And I swear to God, when they walked in, they looked at my legs, and then like all three of them had this response, right? Like they were pleased that I put my nylons on. I won the case. And afterwards, I interview the jurors. And do you know that they all great performance, everything great. They really believe my client, everything fabulous. And then I couldn't resist. I said, okay, you three, what was going on the day that I ripped my nylons? And all three of them started laughing. It was an issue for them. These are two very silly, silly points. Like you should not lose your case because you ripped your nylons and took them off in the car. You really shouldn't, right? But it was a thing for them. And it would have been a distraction for them had I not rectified the situation before they walked into the courtroom that same morning. Okay. So, and it's even worse if the tenant is the one who's being unpleasant. The other thing that tenants need to learn is listen to the question, answer only the question. If the question is, everyone in your heads, answer this question. Do you know what color the sky is right now? Have an answer fixed in your head. If you answered gray, blue, or anything that is actually a color, you did not listen to the question. That question requires a yes or a no. Do you know what color? the sky is right now, that requires a yes or a no. If it matters what you think the color of the sky is, we will ask a follow-up question. This is a very stilted and unnatural way to present information. You are not going to be able to go into a narrative on the stand. You are going to have to answer questions. And if you say that the color is blue in response to that question, the other side is going to say objection, non responsive, move to strike, because that's not the answer to the question. The answer to the question is yes or no. And if you answer, yes, this color is blue, then the other side is going to say, objection, move to strike everything after yes, because everything after yes does not answer the question. Okay. Um, and if you're inside and you answered that it's blue, the other side might grill you about how you know that. How long have you been inside? What color is it? Was it when you were coming in? Didn't you notice that there were clouds in the distance? Right. So you have to really, the other day I did this exercise with a smaller group and it was nighttime and somebody answered it was blue. Well, it's obviously not blue, it's night. It's probably black or maybe there's stars or so you need to really know what you're answering as well, or you're going to get grilled by the other side. Okay. Um, Another pointer on being a good witness is that you have to be able to remember the details. And most people don't remember the dates that things happened, but you have to refresh whatever it is with whatever notes you have that were taken in close proximity to the incident, what happened so that your memory can be refreshed. Another uh, typical thing that happens with witnesses that is problematic is the witness um, will guess, right? Um, and sometimes the question is asked and you say, I don't really remember. And then it's asked again. I don't remember. And then it's asked a third time. And the other lawyer or your lawyer might say objection, asked and answered. But most of the time, the judges let them ask a question several times because what they're looking for is, are you going to change your story? Right. And so by the third time, you're starting to feel stupid. So now suddenly you give an answer, even though you're just guessing. Don't guess. If you don't know, you don't know. And if you didn't know when it was asked the first time, then you shouldn't know when it's asked the third time. And if you didn't know when the other side asked you, you shouldn't know when our side asks you. So it has happened in the past where I've asked a client something and they give a good answer when I ask the question, and the other side tries to query about that, and suddenly they don't know. Okay. So you have to really understand your story. You have to remember the facts of your case. You have to remember them accurately. You have to answer honestly when both sides are questioning you. You can't suddenly start getting evasive when the other side is questioning you. You have to know the difference between a guess and an estimate. If I asked you to estimate the length of your coffee table, you can probably do that. You can get out a tape measure and measure it and then know, or you can guesstimate that it is about 3 feet or 4 feet. If I ask you what the length of my coffee table is and you've never been in my house, you probably, not probably, you should not be making a guess because there's no way for you to know. Okay. So those kinds of things are important in terms of being a witness. And again, likable client. And one of the worst things that you can do is be that you need to sit stoically with a softened face. When we get to be a certain age, we get these little jowls. So when we're sort of like, I can look pleasant if if I'm like this. I don't know if my video is on, but if I smile, I can make my face brighter. But if I'm just sitting there, I can look angry, and we call that resting bitch face. I'm not being angry. I'm just not being expressive, but I look like I'm angry. So if you are older, we need to soften those features by making you look a little bit more animated and not look like you're angry. Um, Another unpleasant thing that clients, both sides will do, is the responding visually or even orally to something that's being said, rolling your eyes, huffing and puffing, being really animated because you really want to say, that's not true, or even saying, that's not true, not allowed. None of that is allowed. You have to sit and be very, very calm. And we give you a pad and paper for you to write down anything that you want to tell us during the break. Nothing worse than trying to interrupt your lawyer when your lawyer's trying to win your case. So we don't want you tugging at us, letting us know things that probably don't matter or that we're going to take care of anyways. If you have two lawyers at counsel table, you can take a note and slip it to the one that's not actively handling the case right there. And if they think it's important, they'll make a point. But more mainly, we want that lawyer who's actually handling the case at any given moment to be focusing on what's happening in the case, not on what's happening, not on that you need therapy over what's been said. Okay. So, and we don't want you scribbling madly. Okay. Because that's also unattractive. So very, you just want to write and then tell us during the break. Okay. Those are a whole bunch of pointers. We actually have a whole presentation on just this: how to be a good witness, how to be a good client in court. And we're going to record it and make it available to people. The next factor of the 16 factors is other leverage. If you come up, I have a case that where the tenant hired us literally the day before the trial and had not one stitch of evidence, and it wasn't a rent controlled unit, and there wasn't a subsidy, and there was no lease, and they're probably not tenants at all because they've never paid any rent. And they had a theory about, yeah, but we've put in our sweat equity, but they had no evidence of the sweat equity. And they hired us the day before. They also claim the owner doesn't want to evict them, and it is the owner's son that has forced her to do the eviction. But he is now the owner. She signed over a title to him, and they want to prove that it was under duress and that she doesn't want to do that, which you frankly can't do in an eviction case. You have to file an entirely separate lawsuit. And besides that, they had no evidence, right? So we didn't have the benefit of doing discovery in that case because they hired us the day before. We couldn't make a jury demand because they hired us the day before. And so if you come at the last minute, we're losing a lot of leverage because we can't prepare the case well, and we're stuck with what you've got, right? With what you've done. Um, Other leverage points are the jury demand, which even with the worst case, the landlord has to think about whether they want to pay their lawyer to do a 5-day jury trial and can sometimes result in a settlement. And then unlimited attorney's fees. You need to look at your lease. Most leases have a provision that says something about attorney's fees if there's a lawsuit. Most of the time, actually, they used to all say, in an eviction action, the loser pays the winner's attorney's fees. Or it might say the tenant pays the landlord's attorney's fees, but that's interpreted to mean the loser pays the winner's attorney's fees. And so for us, that's a leverage point. It's a double-edged sword with the blade sharper on our side. Why? It's easier for us to collect against your landlord than it is for the landlord to collect it against you. But it is something you need to think about, that you've got a possibility that if you lose, you're going to owe a lot of money. It's one of the factors. On the other hand, it weighs more heavily on them. And I have gotten a lot of last minute settlements. Like the whole time they're saying no, 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 no. And then at the last minute, they give us exactly what we want. And the leverage point is the risk that they're going to have to pay us 20, 30, 40, $50,000 because we've litigated this case to the hilt, and we get our hourly billable rate. I've been paid as high as $550 an hour by judges in these attorney's fees motions. And so that ends up being a factor they consider to give us what we want. The next set of factors is the client's finances, meaning how collectible is this client? Does this client have good credit or care about their credit? Some of our clients they're not ever going to have good credit. They're on AFDC or Social Security benefits. Their credit is already not good. But if you are young, upwardly mobile, um, have you know, the desire to buy a house, have a job where you get a paycheck, have a job that is a well-paying job where you get a paycheck, we will take fewer risks than if you are on government benefits. Why? Because if you're on government benefits, they can't ever collect that money from you. The government benefits cannot be garnished. You just have to make sure that your benefits go into your bank account. You have to keep the bank account empty so they don't grab them and then we have to go to court to get the money back. Um, but if you have a regular job and you get paid with a regular paycheck, they're going to be able to garnish your wages, meaning take it directly from your employer. And if you're a day laborer, undocumented with a common last name, don't have a social security number, don't get paid a paycheck, how are they ever going to even ruin your credit, right? So we the level of risk that we can take based on our client finances is a factor that we consider. Related to that is how difficult is it going to be for this tenant or this family to find a place to live? So, if you are a single individual with a job, relatively good credit, then more likely we will, it's a factor that weighs in favor of not taking a chance of losing at trial. But if you are a large family that is currently what we call underhoused, you're in a 1 bedroom when really you're going to need a 3 bedroom to be able to rent in this market because there's 6 of you and no one else it's going to be hard to find another 1 bedroom. Then we want to save that 1 bedroom unit, because if you can't afford the 1 bedroom, and that's why you're in eviction proceedings, how are you going to afford a 3 bedroom? How are you going to afford a 1 bedroom in this market, let alone a 3 bedroom? So we really need to fight to keep that family in. The same thing for seniors, people with disabilities, people who it's going to be hard for them to find another place to live. Another example, I once had a case where I forget how many, a huge number of families, I don't know, 20, 30 families came to an initial meeting. They had 60-day notices to quit, no cause. There was no rent control or rent stabilization to protect them. This was before the Tenant Protection Act. Many units were unprotected in Los Angeles at the time. In Los Angeles, to be protected, the unit has to have been built before October 1978. These were built much later. The landlord, so the only defense in that case is either retaliation or discrimination. All the tenants were Latinos. The landlord was another race. I can't remember what, but it wasn't discrimination because he rented to all these Latino families. So obviously he doesn't have a problem renting to Latinos. What had happened, though, is there's a program in Los Angeles called the Systematic Code Enforcement Program. Once every 3 years, they inspect all the units, and the place had a lot of problems. The owner had managed to fix up 3 units, and the manager was going to direct the inspector to the 3 fixed units. The rest of them still had a lot of problems, and the landlord asked them to not open the door, to not be home, so that the inspections could not happen. Tenants neither cooperated or not cooperated. So that is to say, they didn't organize themselves and say, oh, hell no, we're not going to, help this landlord commit this fraud. So they just did some people were home and they let the inspector in, and some people that weren't home didn't make a point of being home. So the landlord got mad that he got cited for all the units that weren't fixed, that let the inspector in, and so served notices against all of those tenants. If you let the inspector in, you had a notice. But he's smart. He actually also served notices against a scattered number of people, not all of them, but some people who had not been home. So retaliation, it would have been stronger if that organized and said, yes, we're going to let the inspector in. So it wasn't a strong retaliation defense. And I was the third lawyer they talked to, and I agreed with the other two that these cases probably could not be won. Therefore, and this is also before the May 2016 housing crisis. So most of these families were going to be able to find another place to live. And I was right. Out of the 20 or 30, I can't remember how many that came in, 11 couldn't find housing. What were their characteristics? They were larger families with less income, like rent burdened families. They were already paying more than 30% of their income rent, seniors, and a person with a very severe disability. It was too hard for them to find housing. I represented them. Eventually, the way that the case got resolved is they all moved out. But I got them enough time to save enough money and enough time to find housing. And I think something like eleven or $12,000 each, which at the time was a significant amount of money, to be able to move, even though they weren't entitled to that relocation. And what's interesting about that case is that the lawyer on the other side was new on the scene. And so he calls me one day and he says, if you're going to fight this, I'm going to set depositions for every adult in the household. So it would have been like 40 depositions, and I'm going to set them in Orange County. I'm going to tie you up in depositions for the next, like he's being really tough. I said, okay, uh, serve your notices. We'll make someone available. He took one deposition. He set them every half hour. And I showed up with two clients on the theory that when the first one ends, we'll call the third one. He took one deposition, realized that this was going to cost his client a fortune, realized that I was prepared to be there, however long it took to take 40 depositions. And so he ended up then accepting an offer that would get people stabilized. Okay. Um, so so that's the client finances. The next thing we look at, so let me actually summarize the value of the unit. What's the rent? What's the size of the unit? What area of town? What are the amenities? Is it protected? Usually we're looking for a rent stabilization law or a rent subsidy or an unexpired lease. Can we win because we've got the law on our side and good evidence, good witnesses, and our client's likable? Other leverage, like you came to us early enough for us to demand it, go do a good answer, demand a jury, propound discovery, and also an attorney's fees provision that is unlimited is extra leverage to get a deal because they don't want to take a chance of owing us a lot of attorney's fees. The characteristics of the family, their finances, their side, how difficult is it going to be for them to find other housing? And then the next factor is what is on the table? What are you risking? Um, so as the case progresses, especially if you're in a below market rate unit, they're going to be making offers, and the offers get better and better. So a good example that I've been using a lot at these webinars is a client who on case two did not do exactly what they needed to do. And so we are in a position where we might not be able to win this, but her rent is in the $400 range. Been there 42 years. So we've been fighting to stay, likely lose, do a motion for relief from forfeiture or a hardship motion to reinstate the tenancy. But then the landlord put $75,000 on the table. The saved rent is not very much because the rent is so low, but the $75,000 is nothing to sneeze at. Now, because of her income situation, $75,000 really doesn't get her into a better housing situation. And so we haven't really known what to do, and she's also indecisive. But next week we have to decide because it's coming up for trial next week. And now it's a very, very ripe case likely to go out. So we really need to figure out what to do with that one because we are risking something that is of significant value. Um, Another good example. Actually, let me do the questions. These are two scenarios. Okay, is normally in this eviction process, the time between losing within losing, and a lockout is 3 weeks, right? 14 to 21 days. So in this case, we were offered 3 weeks to move if the tenant paid all the back rent, um, and a sealed record. So think to yourselves, is that a good deal? And you now have that answer in your head. And the answer to the question is, well, it depends. I made that deal. I made that deal on behalf of a young man who was a single individual living in a luxury unit, nothing wrong with the unit whatsoever. There was a leak, so the box of plumbing problems, a leak, but just a little drip in the sink. That's a plumbing problem. And there was one missing electrical plate or something like that. So the box for electrical was marked, but there was no way to win on that. And it was not rent controlled. The notice demanded exactly what he owed. There was just no way to win the case. Um, so if we had gone forward to trial, we would have lost, right? And if we would have lost, he was collectible. He was a financial consultant mortgage broker who had lost his job, gone through his not adequate savings, which says something to his clients, right? A financial consultant that didn't have adequate savings and ended up in eviction proceedings. He'd just gotten a new job. If an eviction was on his record, then that would ruin his career. So the most important thing for him was a sealed record. So that was a good deal in that context. I also had a client who worked at JPL or some other like high security situation, and eviction on his record was a problem. Evictions are sealed from the moment they are filed until through the resolution of the case. And so, and if it's resolved in your favor, then they'll be permanently sealed. So that's why having a deal that seals the record can be so important, particularly if you have usually this comes up in the context of career. Also, for Section 8 tenants, generally, if they lose the eviction, they lose the voucher. So we are much more cautious in dealing with Section 8 tenants about taking cases to trial because we don't want to lose the voucher. The voucher is also at risk. Um, Another story that I like to use is a case where the owner was demolishing, I think they were demolishing 6 and building 4, or demolishing 4 and building 6, I can't remember now. Uh, but they were demolishing rent controlled units and building condominiums. Hugely in Venice, hugely overpriced condominiums. They were going to make a fortune. My client was the last person, and they had made a mistake on her paperwork. We were going to lose this case. There are no guarantees, but it was one of those, high probability of winning. We were going to win this case, win it because of the technicality, and then they were going to have to start all over. We did some research and realized that they had a construction loan that they had to break ground by a specific day, and if they didn't, then they would have to get a new loan. And we had a forensics person figure out that in terms of delay and all of the other factors having to do with a new loan would cost them about $300,000 to do that. So I thought I could get her a deal, total value $200,000. When we got to 133, which was 100,000 in new money and 33,000 in saved rent, she took it. Now, was that a good deal? Well, from my point of view, good for her because it's what she wanted, and we were going to lose the unit eventually anyways. And $133,000 put her in home ownership. But I probably could have gotten, if she had stuck to her gun and played a better game of poker, we probably could have gotten her to $200,000 because the landlord couldn't afford to not break ground on time. So again, taking into account all of these factors, tenant always makes the final decision. I'm not the one taking the risk of rejecting that offer right now. She is. And so it was good enough for her. And so we made that deal. Another factor is, who are the players? Meaning, who's opposing counsel? Who's the landlord? Who's the judge? Um, Once we know the judge, we also know what our jury pool is going to be. So, for instance, Pomona, very fair judge, a judge that is a good settlement judge too, including not having a bias that the tenant has to move out. But our jurors will be more conservative. Downtown, the four judges that currently handle the four courts downtown, they are all acceptable to the defense bar, relatively neutral, all of them. Doesn't mean that I agree with them every time. I, sometimes we get very bad rulings out of particularly two of the four judges, but they're acceptable. You have a fair shot of winning. They are in the middle, right? And the jury pool is going to be great. In downtown, we get jurors that will say things like, when you ask them, this is an eviction case and that's all you know, what do you think happened? Jurors will split into three groups: those that assume the tenant did something wrong, and those that assume the landlord's just trying to make more money and raise the rent, including tenants that use the politicized word gentrification. Oh, the landlord's just a gentrifier, because there's been a lot more organizing and education in the downtown area. And by downtown, I mean greater downtown, including Koreatown, Echo Park, Silver Lake, all the communities that feed into the downtown court, because those are gentrifying communities. People are aware of the pressure that landlords put on tenants to move out so they can raise the rent. So we get a much more politicized jury pool. And then the third category are people who just want to know more, people who are neutral, however, don't have a bias one way or the other. But downtown juries, good for tenants. Chatsworth juries, not so much. Santa Monica juries used to be good for tenants because there were a lot of tenants in Santa Monica. But Costa-Hawkins, the law that allows the rent to go up to market, has resulted in the mass displacement of tenants from the west side. So now most people on the west side are either homeowners or tenants that are affluent. And again, affluent people are not going to be able to relate to someone who can't pay the rent. So we don't get as good a jury pool. And then the client, right? How good is the client? Again, consider that we talked a lot about that here. And then your own lawyer. Um, if I do say so myself, I'm a very good lawyer and an even better advocate, and I'm a good trial attorney. Um, and Eden has three very solid trial attorneys. We're also training a bunch of new people. Now, we don't send our new people to trial by themselves the first time. But but there will be a point at which your lawyer will be soloing. I mean, there could be a case where your lawyer is soloing for the first time after having second chaired two or three cases and first chaired two or three cases. Based on how I train people, that should be um, good lawyering. But I will admit that it's not the same as having a lawyer who's done, I don't know, I can't even imagine how many trials I've done, too many to count. And so we do pay attention to that. So for instance, we don't send someone to solo for the first time on a complicated case. But sometimes the forces, like it did happen to me once. I was training a young lawyer, and uh, two cases got sent out at the same time. She had second chaired a bunch of cases. She had never first chaired. And two cases got sent out. And at the time, it was private practice. There were two of us. So in on the same floor of the same courtroom, there were two trials going on. Both of us won, but I will tell you, I was very anxious about not having watched her. She actually second chaired me on about six cases. Um, she'd been really, really carefully, uh, like she was chicle on chancla, which was gum on my shoe, stuck to me for a year before this happened. And so she was very, very well prepared and quite brilliant and very charming. Um, but but I have to say that I was nervous that the only thing I'd ever watched her do is opening statement and questioning our own witnesses. The tougher part of a trial is cross-examining the other side's witnesses. I never watched her do that. But again, it worked out just fine. But it's something to consider because There are 500,000 people at risk of eviction right now and 60 lawyers in the entire system to handle all those cases. And a lot of them are new. So there's going to be that issue of having a lawyer that doesn't have enough trials experience under the table. Not so much with our agency, but I know it's been a real concern that we have so many newbies in the system. And then going back again to, can we win? Looking at all these factors, can we win? Okay. So at this point, it is close to 11. So I'm going to very quickly go through, what do the papers look like, so that when you talk about your case, you're using the right words. And I am going to be impatient when I'm interviewing you about you using the wrong words. Okay. So if you say, I have a notice to vacate, that doesn't tell me anything. It could be a 5-day notice to vacate that the landlord gave you and has nothing to do with the sheriff and the case has never been to court, or it could be a 5-day notice to vacate from the sheriff. So you need to be able to very, very clear. So again, the eviction process starts with a notice. These are the types of notices: pay or quit. This is the minimum number of days required by the law. Cure or quit, quit for nuisance, quit no cause, quit no fault. So there's a cause, there's a reason. It's one of the reasons allowed under the local rent stabilization law or under the state tenant protection act, if that's what protects you. But there is no fault. You are not at fault. You haven't done anything. It's that the landlord wants to use the premises for another person purpose. They want to move in themselves, move in a resident manager, move in a family member, a close family member. They want to demolish, convert to condominiums, do something else. Section 8 tenancies can be terminated on a 90-day notice. Actually, what can be terminated is the subsidy. The tenancy is supposed to have its own separate notice to terminate, but usually a Section 8 tenant who's paying a portion of the rent, 30% of their income in rent, and the government is paying most of the rent, can't afford to have the subsidy terminated unless they're in a rent stabilized unit, in which case the landlord can evict them. I'm sorry, can terminate the subsidy, but can't evict them, and the rent is whatever the tenant's portion of the rent is. So it's there's a way to negotiate that notice away. The Ellis Act is allowed in rent stabilized units. It allows the landlord to give a 120-day notice um, to quit, so that the landlord can take the units off the rental housing market, either demolish, convert to condominiums, convert to some other use. And that is allowed, but the tenant can, if they're disabled or elderly, apply for a 1-year extension. And then we also have situations where you're on a lease, it's a 1-year lease, and it specifically says that it terminates at the end of a year. And a notice is not required at all. Okay. Um, uh, Again, at 1 o'clock, we talk at more length about this. And so, Kevin, can you put all of the webinars up in the chat right now? So we have webinars on Tuesdays in Spanish at 6 o'clock, Thursdays in English at 5 o'clock, and Saturdays um, in English. But if a Spanish speaker comes, we theoretically have the capacity to accommodate them, or I might do it the way that I did today. Now that we have recordings, have them listen to the recordings and come back to the Q&A. And those are about general tenant rights. But I do feel like you need to know a little bit about it for this context. So this is the state of California, and this is the county of Los Angeles within the state. And then this is the inset. The county of Los Angeles used to be one jurisdiction, one government, one set of laws locally. But then cities started forming, 88 of them. And they incorporated and brought in their own government, and some of them have their own laws that protect tenants. LA, city of LA is the red. The gray are the other 87 incorporated cities in the county of Los Angeles, including Catalina. And the white are the areas that are still unincorporated LA County. So there are rent stabilization laws in unincorporated LA County, these blank areas or white areas, Baldwin Park, Beverly Hills, Culver City, Inglewood, Los Angeles, Santa Monica, and West Hollywood. Um, and there's an eviction protection ordinance in Glendale, which means that the tenant cannot be evicted without one of the four cause reasons. So you can't serve a 30 or a 60-day notice to quit no cause. But to get rid of a tenant, the landlord can raise the rent to market and then serve a 3-day notice to pay rent or quit when they can't pay that rent. So it's not a very strong law. If each of these laws have a definition of what unit is protected. For example, in Los Angeles, it says all your residential dwelling units are protected. Everything is protected. And then there's 10 exceptions. The biggest one, any unit built after October of 1978, not protected. Why? Because developers come in and tell the city council, hey, we're never going to build again if you don't exempt new construction. And so they exempt new construction. And so then we have a law that doesn't protect anything after October 78 because that's the date that the law was passed. And each of these laws is a little bit different, with different requirements, different start dates. Another exception to the law in the city of Los Angeles is single family homes that are being used as single family homes. So if you live in a single family home and you're the only family or household there, and it hasn't been illegally subdivided or isn't being rented as a boarding house, or there is an illegal garage unit, then you're not protected in the city of Los Angeles. And then there are a whole bunch of other exceptions. In all the laws, they exempt um, student housing, boarding care facilities, cooperative housing, housing that was built with subsidy money, nonprofit housing, etc. But you have to really know the law to know if your unit is protected. If your unit is not protected, then we look to see if the Tenant Protection Act covers it. The Tenant Protection Act, which is the state law that was passed in 2019 and went into effect in January of 2020, and was passed through the efforts of tenant advocates who mobilized. And in another presentation, we do this in detail, but what actually happened was we tried to repeal that vacancy control law, Costa-Hawkins, which did a lot of things to weaken rent control, including prohibit vacancy control. We tried to repeal it in 2018 and lost very soundly. The next day, the Alliance of Californians for Community Empowerment, which I encourage you all to join, or join tenants together and join your tenants union. Kevin, if you could put those links in the chat, that would be great. Basically called a demonstration the day after we'd lost. And frankly, I was tired and licking my wounds and trying to not figure out how to get revenge against people who didn't walk their precincts. I was so pissed when they call and invite me to a demonstration, and my head said, okay, you guys are crazy, but my heart and my voice said, of course I'll be there, Peter, because I always do what the organizers ask me to do, because it is important for us to be part of a movement. And with it, by March, ACE had called for a statewide rent control law, and everyone, including me, thought they were crazy. But again, I signed up because why not? We have to keep trying. And what I hadn't thought of is that landlords were so afraid of losing vacancy control and having us come back again to try to defeat or eliminate Costa-Hawkins, that they were willing to give us a statewide rent stabilization law. And it's a decent law, considering that like who was in the movement. It protects any unit that's at least 15 years old. It exempts single family homes unless they are owned by a corporation. Same thing with condos. So usually in a rent control law, condominiums and local and single family homes are not protected. In this law, we got an exception for corporate owned condominiums and single family homes. Why? Because ACE organizes in developments where, I'm sorry, not in developments, organizes tenants whose houses were bought out, whose single family homes were bought out by Wall Street investors during the 2008 mortgage crisis. It was important to them to um, protect their members. So, in school we learn how a bill becomes a law, and we talk about the inside of the process, right? One house looks at it and passes it, the other house looks at it and passes something slightly different. There's a reconciliation. They get a bill that goes to the executive, in this case, the governor, if it's a federal law, the president, and then it gets signed into law or vetoed. But what really happens outside this process through with lobbyists. There are meetings with the landlord lobby, the realtor lobby, the insurance lobby, and yes, the tenant lobby. We have a tenant lobby. There are organizations in Sacramento and organizations in DC that advocate for tenants' rights. In California, it's a coalition called Housing Now. ACE is a part of that. Eden is a part of that. The LA Tenants Union, the Pasadena Tenants Union, a lot of the tenant unions are a part of that. And so in that negotiation, ACE refused to leave the bargaining table until their members in single family homes and condos were protected. A weird exception in this law is duplexes if the owner lives on the other side. And no one's been able to tell me how that happened, because that's a weird exception. And my best guess is they needed a crucial vote. And that legislator had a story about a little old lady and a nightmare tenant. And so we got this weird exception based on needing one vote. Now, would we have needed that vote? And I'm just making this up. No one's been able to tell me. I can't fathom any other explanation. Um, the point is that if we don't need that vote because we have plenty of other votes, because the legislators are as afraid of us as they are afraid of the landlord lobby, because they have money but we have votes, and so we can get them unelected as well. When they're up for re-election, we can wage a complaint against them, just like the landlords threatened to wage a campaign on. If we're in that kind of level playing field, because every tenant in California is empowered and educated and recognizes that they are part of this uh, group of people, that if they are activated and vote their economic self-interest, can get strong laws, then we can get much stronger laws. But the TPA has, I don't want to like act like it's not fabulous. It is fabulous. I can tell you it changed my life. I'm a homeowner, but I'm a people's lawyer, and pre-pandemic we did 3 clinics a week. During the pandemic, we moved those clinics into virtual clinics. Those clinics would get, pre-pandemic, not atypical, 45 people, 45 households would show up, and 40 of them had 30 or 60-day notice to quit, no cause, or huge rent increases $2,000 in one step. Why? Because they didn't have any protection at all. So those notices were legal. There were nights when I would like end the clinic and just need to cry for 30 minutes because I had told so many families bad news, right? It is nothing more heartbreaking than telling a single mother with 6 kids that even though she's been there for 24 years and her landlord never raised her rent because they were a good guy, now their landlord died and the greedy kids want to kick her out and there's nothing we can do because she lives in a single family home. There is nothing more heartbreaking. Well, I guess there are things that are more heartbreaking than that, but it's pretty heartbreaking. And I would have to do that too many times in one night. Not doesn't happen anymore because most tenants have some level of protection in California because of the Tenant Protection Act. And so, but the Tenant Protection Act has 4 significant weaknesses. One of them is it does not protect people until they've been there for 13 months. So many landlords will not renew a lease so that you don't establish a TPA protected tenancy. Another is substantial renovation, renovation. which is they can put in a X amount of dollars into renovating the place, and then decontrol the unit or get it out of um, the protections. The third is that the allowable rent increases are 5% plus the consumer price index, no more than 10%. That can be huge. And so it's a loophole we need to close. And I am forgetting the fourth loophole. And if I remember it, I will let you know it. We need to close those loopholes. And we, as a coalition, will be discussing uh, whether it's feasible to do that. Maybe the fourth loophole is vacancy control. We still really, 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 really need vacancy control in order to make sure that people are not pressured into moving out and harassed into moving out. Um, in addition to these laws, we have these emergency laws. So there are protections under these series of laws. This one was passed in September. I forget when this one was passed. I think in this was September 2020. This was in the spring of 21, and this one was most recently. These laws have now all expired. To know exactly how they help you, you need to come to the 1 o'clock webinar. Um, there is still some protection for people who didn't pay rent between March of 2020 and the end of and September 2021. But for October rent, there's no protection here, except if you apply for the rental assistance and if you're approved, an eviction cannot move forward. And the other exception is before a landlord can file an eviction action for non-payment of rent, they have to declare under penalty of perjury that they are cooperating with rental assistance. So those are two benefits. 40 of the 88 cities pass their own local laws. Some of them let them lapse. Some of those local laws are stronger than the state law. And there is local protection in the county of Los Angeles. This law, AB 3088, which was passed in September, has a preemption provision that says that if a local jurisdiction already had a law in place when this law was passed, then that law 100% viable. But if it didn't have a law in place when this was passed, then anything having to do with rent payment in a law that was passed later, it preempted, and so it doesn't exist anymore now that this law took away that protection. So City of LA passed a law well before this, and that law has been in place continuously, therefore not preempted. So tenants in the City of LA have more protection. Similarly, City of Pasadena, that law is still full on in place. I don't have all the other cities memorized, but there is a tracker that we show you how to use for how to find your city's protections at the 1 o'clock webinar. What is really disheartening is that the County Board of Supervisors was renewing their law every month and then every 2 months. And so the prevailing opinion, I'm not sure. The prevailing opinion right now is that the county law is preempted on all issues having to do with rent payment. And so for October, if you live in a jurisdiction that does not have its own law that protects you for October, you don't have protections in October. Okay. The county law, other than those protections around non-payment of rent, protects you unless your city has a stronger law. And then there was this CDC order for a while. It was invalidated by the Supreme Court. It didn't really protect a lot of people in LA County because most people were protected by these laws. we were using it to protect people who got into eviction proceedings before the pandemic. And so these laws don't apply. And so we were keeping people in place because of the CDC order. But we had about 258 people that were only eligible for that order. So that's how I'm at guesstimating that's probably 2,000 countywide. And we were smart about getting our people to look for housing by letting them know that these solutions were only temporary. Okay. Now, over here, I explained to you types of notices. These are pictures of them. They can look in very, very different shapes and sizes. I used to say you can carve it on a pumpkin as long as it has the right word, but the clerk won't take one carved on a pumpkin. They might take a picture of the pumpkin and you might be able to file it electronically. But most of the time they look like this. They are in writing. People will say, it's not even signed by anyone. Doesn't have to be signed. It has no official stamp. Doesn't need an official stamp. They took it off the internet. That's where they take them from. It does have to have required language depending on the type of notice. And if it doesn't have that required language, then it's a defense to the eviction. Um, and Eden does not give advice to landlords. When we see a defective notice, unless we can get it canceled and there's no chance they're going to bring a new one for something else, we don't tell them, nanny, nanny, you had a defect, because what are they going to do? They're going to correct the defect. And then you're going to find yourself in eviction proceedings without a defense. So we would rather have them file that eviction lawsuit on that defective notice, litigate the case, and offer a permanent solution so that we are not coming back on another case with no defects in the notice, and resolve the case so it doesn't come back. Service of a notice is has to be in person, but if you're not home and somebody else answers the door, it can be handed to that person and sent by regular mail. If no one is home, it can be posted on the door and served by regular mail. And the code actually says that they have to try to serve you. If they can't serve you in person, they also have to serve you where you work. Truth is, there's cases that say otherwise. It's not really a requirement. And during the pandemic, we have had a couple of cases where the landlord did go to the person's place of business, but their motivation wasn't to make sure you get the notice. Their motivation was to embarrass you in front of boss and coworkers. Generally, it happens by posting and mailing. Tenants often complain that this is harassment. Now, it can feel like harassment to get bunches of notices, and it can be harassment to be sending you one notice after another. I had a case of an elderly woman who had a very long rent control tenancy, and the landlord one day says, I need you to move. It was a duplex with a common area. Actually, it was a duplex with a backyard, but her backyard also had the garages. So her backyard, even though it was her backyard, and the other side had their own backyard, was really a common area backyard because both tenants had to go through her yard and there was a door, a gate between the two yards. So protected by rent control and the land and very low rent, and the landlord comes and says, my daughter is going to live here. And she researches her rights and realizes, oh, they can do this. And the daughter is going to come home from college. So it's probably legitimate, but she was entitled to, I think, $19,000 in relocation at the time, and the landlord wasn't giving it to her. So she said, no, I mean, I'll move if you give me a 60-day notice, follow the rules, and give me my relocation money. The landlord refused. Instead, he started not making repairs, took away her washer and dryer, which was really a big thing for her because she was older and now she's got to go to a laundry room. Um, Took away her garage, which they're allowed to do under LA rent control as long as they reduce the rent. Told her she couldn't have her dog in the common area backyard because you can't have a dog loose, unleashed in a common area backyard. Then took away her right to park in front of the garage, forcing her to park on. So this is all clearly harassment. but all of it allowed under the law. And so we're working on getting stronger rent stabilization laws that prohibit taking away amenities or things like this, right? And now we have laws that uh, consider it to be harassment if the landlord refuses to make repairs. For her, the last straw was the landlord was a had a gardening company, and so would come and do the gardening. Can everybody please mute? I'm hearing noise. Would come and do the gardening at 7 o'clock every morning with a leaf blower. A reasonable accommodation request asking him not to do it because she had medical issues that kept her up into late hours of the night, and therefore sleeping was the mornings were important for her sleep. Eventually, she moved out, and another lawyer filed a lawsuit for retaliation and a whole bunch of other constructive eviction, etc. And then when he couldn't settle it in mediation, dumped the case. And she came into this clinic I used to do in West Hollywood, and it was all really well prepared. And so I said, okay, I can spend 5 days doing this trial, right? And so I did the trial, and during the course of the pretrial discussions, the other side argued that all of these activities were legal and that they were all protected by the litigation privilege. Oh, the other thing the landlord did was try to evict her, I think, 5 times for falsely accusing her of non-payment of rent. And every time, the morning of trial, he would dismiss, but he was costing her money in attorneys because she was hiring an attorney for each of those evictions. So, but that's all litigation privileged, right? You can't really sue for that. And so there was this whole argument, and I won all those motions, and we were allowed to do our trial. But I was worried that eventually this would get appealed because I was concerned about the litigation privilege and about the fact that all of this was legal activity. So we mainly made our case about the difference in the rent between what she was paying and what the new tenant, because she moved out voluntarily before she met me, well, voluntarily in quotes, what that difference was. We didn't even bring in an expert to get the real value of that difference because he wanted $15,000, or I'm sorry, no, he wanted $5,000. And so, what if we don't win, or what if we ultimately get appealed and then we don't recover those costs. And so we just went on this raw numbers. And I also advised against having her doctor come in, and then we would need an expert to testify about the emotional distress. And we just had her describe her own symptoms. As a result, we got $89,000 in the rent differential, which is what we were asking for. It's the difference in the rent times her life expectancy. And we got $2,000 in emotional distress. We would have gotten a lot more with expert witnesses. We win, and the landlord makes a motion for judgment notwithstanding the verdict, saying, this is all litigation privilege, this is all stuff that's legal. And we lose those motions. And my response to the judge was, I'm sorry, we litigated all of this in pretrial motions and you ruled in my favor. And the judge literally said to me, Miss Pop, I know you, and I know you as a very ardent advocate. And I figured if you lost the motions in limine, you would just appeal me. I never expected you to get a verdict from the jury, and I'm not going to compound my mistake in having granted all your motions or denied the other side's motions by not acknowledging that there is this litigation privilege and that all of the activity is legal activity. He didn't do one thing that was illegal. And so the tenant got mad at me, fired me, hired another lawyer. I tracked the appeal, and the other lawyer just dropped it. Why? Because he did his research and there was really no way to win because of the litigation privilege. And because the tenant harassment laws at the time were not strong enough to protect her. Okay. So that's a bit on harassment. Like, that is a very harassing case, and yet she got nothing out of it because we need stronger anti-harassment laws. During the pandemic, we managed to pass one in the city of LA. Santa Monica and West Hollywood also have anti-harassment laws, and now the county also does as well for people living in an unincorporated county. Um, so, uh, what is not harassment is what's on the screen. Oh my God, the landlord's harassing me. They've sent me so many copies of this notice. It's one to you, one to every other adult occupant in the unit, and a one to all unnamed occupants. The purpose of which is to make sure you get the notice. They posted on the door. It was openly posted. It's an invasion of my privacy. Truth is, it's supposed to be posted to make sure you see it. They brought it to my place of business. Again, rarely happens, but the law says that they should try. Um, Now, I'm going to show you the types of notices. This is a 3-day notice to pay rent or quit. It's to here goes all the names of the occupants they know and anybody else in possession. You are in violation of your lease. You haven't paid this amount for these months. The pre-pandemic rules don't require them to say what months, and if they miss the boat on the months, not a problem. But this amount has to be exactly the right amount. Or I'm sorry, not exactly the right amount. It can't be more than exactly the right amount. It can be less, but not more. Otherwise, it's defective. During the pandemic, the months also have to be accurate. So if it's for pre-pandemic rent, they don't have to say what months it's for, and they can say it's for January and February, and you can come up with the receipts for January and February, and they can say, yeah, but we've been applying the rent to a payment they missed, a year ago, and therefore it's still for January and February. Even they can prove January and February rent payment. Then here it says, if you don't pay within 3 days, we will initial legal proceedings for unlawful detainer, which just means eviction, and we will declare the lease forfeited. And if they don't have this forfeiture language, we can go through the entire case, and at the end of it, we can just pay the rent, because the lease is still viable. The problem with that is then the sheriff's going to try to evict you. We're going to have to file a lawsuit, but still. And then it has to have date, who the agent is, and the human to pay, the address, the phone number, and the hours. This one's defective. This one's good. This one's defective. I think it's missing the date, time, and hours. This one is defective because it doesn't have the election that the lease will be forfeited. This is the declaration of COVID relief that we have been recommending that tenants send to their landlords. You'll learn at the 1 o'clock that actually, if you didn't pay rent for any of these months, the landlord has to send you a 15-day notice. They have to send you an explanation of the law. They have to send you a blank declaration. And if they don't, then they can't proceed in an eviction. But landlords lie. Not all landlords, but many lie. They'll say they sent you this, and then they will it'll be your word against theirs. So we've been recommending that people proactively do this before their due date. Another story, during the pandemic, I had the sad experience of working all weekend on a motion to set aside a default judgment for a tenant in Chatsworth. Mondays, they usually don't do lockouts, and so we had gotten her case late on Thursday. We have to give notice the day before by 10 a.m. So we gave notice before 10 a.m. on Friday for Monday. We should have been fine. This woman had sent her declarations every month, not herself, but an agency sent them for her certified mail. So she could prove she had sent them every month. The landlord had nonetheless alleged that she never returned his declaration. She was never served a 15-day notice with an explanation of the law and a blank declaration to fill out. She did not get a courtesy notice of the eviction from the court. She got no papers at all until there was a notice to vacate posted, I believe, on the gate. This was like a 6 unit gated kind of deal with the mailboxes outside of the gate. Somebody had burned the mailboxes, and so during this period, there was a table with a US Post box, just an open box, and all the people who lived in that little enclave near Chatsworth, someplace in the northern part of the county, would just pick out and come go get their mail. The landlord lived a couple of doors down, and he also would sometimes get mail there, so he had been seen getting mail out of that common box. It's probably why she didn't get anything prior to this. She was lucky she even saw the posting on the door. I bet you he would have taken it off had he seen it before she did. This does happen. Great case. Unfortunately, on Monday, we got her off to court in enough time to go and do her filing, but on her way out, she was a victim of domestic violence, and her perpetrator stopped her, and she missed the filing deadline that morning. So we noticed it for the next day. The next day, I had her send her adult son to do the filing because in Chatsworth, they do tend to evict the next day. And sure enough, while the young man was doing the filing, she was evicted by the sheriff. And there's nothing we can do once you're evicted by the sheriff. The court takes the position that that their power or jurisdiction is over. And honestly, we don't have enough resources to help everyone who is in eviction proceedings. There is no way that we are going to invest resources into what it would take to get her back in. I don't even know what it would take, but probably some sort of writ to the appellate department and an affirmative lawsuit to an affirmative litigation, affirmative lawsuit. Um, sorry. Um, to reinstate her, arguing that the landlord, we'd have to prove the landlord stole all this stuff. Like it's like climbing Mount Everest with her and her 4 kids on my back. There's just no way it's going to happen. And while we're climbing Mount Everest with her and her 4 kids on my back, a whole bunch of other people are going to get evicted that have a greater chance of uh, saving the tenancy. And I'm telling this story because there are several people here who are trying to get me to climb Mount Everest. And it's something that we need to do very, very cautiously when it's a long shot. And it's going to keep us from helping other people. Oops, my battery is dying. How is that possible? All right. During this next part of the presentation, I'm going to whip through very quickly. What we are not opening cases at the notice stage. At the notice stage, we expect you to keep coming back to the webinars until you can teach it. Okay. I've already been to a webinar. You know what? If you had paid attention and absorbed everything, you wouldn't be coming to the one-on-one because you wouldn't have any questions. So you need to come to the webinars until you can teach it. And we're doing them online. There are now 2 in-person webinars, not webinars, but clinics. They are not Eden clinics. I think we need to kind of put the addresses and times for people that have digital divide issues. But mainly I'm recommending that people stay on the online ones. These are reserved by for people who can't get online. And there are people who really can't maneuver the Zoom at all and can't get the help. So we want to make sure there's a place for them to go. And there we will explain the laws and the emergency protections and everything that you need to get ready to defend the case and where to get legal help. And I can tell you that if you stick through the webinars even though we're not opening a case, and keep coming back and asking the general questions and getting the one-on-one, even though sometimes I get cranky at the one-on-one when people ask questions that I know they're asking because they weren't paying attention. Um, Ask your question and let me be cranky and get the information you need because it'll keep you in your housing. Um, but that's how we're doing it. And I will tell you the story of the guy who didn't like that as a system and kept wanting us to open his case and then gave up and then found some private attorney that then screwed up his case. We could have won his case if he had stuck with us. So stick with us. Um, the the webinars again are on Tuesdays at 5 in Spanish. If you are an English speaker, please don't come because frankly now we're doing it on like when I'm doing it and I know there's English speakers, I get tempted to do English and Spanish. Now it's a recording. So don't come to Tuesdays, come to Thursdays. Thursdays is for English speakers. Um, and then on Saturdays, it's bilingual at 1 if necessary. And then this one at 9 o'clock on the eviction process. And then we have office hours on Mondays and Wednesdays. No presentation. You go on the link. You're held in the waiting room until I see you. I see people in the order in which they arrive. I do give cuts to people who are members of tenant unions who are there with a solidarity caseworker because I don't want the solidarity caseworkers wasting their time. So I will give cuts to people who are there with solidarity caseworkers. And but generally seen in the order in which you arrive. And in the chat, you can see the order that I am seeing people. Please don't walk away from your computer. I spend 2 or 3 minutes trying to get people to connect to the audio. Please know how to connect to the audio so that time doesn't get wasted. And please unmute as soon as you come on. And then we'll do a little 10 to 20 minute one-on-one to tell you exactly it's to address things that don't get covered in the presentation, which really is very rare. But you know, uh, at the 1 o'clock we explain this chart, and we also explain this in a lot of detail. And it's for people who haven't paid rent during the pandemic. We also explain the COVID laws and the rent stabilization laws in more detail. That way you know more and more about the law and not just the process. Same thing with cure or quit notices. This is an example. They have to tell you what you're violating and how to fix it and provide witnesses. And it has to have that forfeiture language. And really, we should, and these are complicated. And so, for instance, if you're trying to decide whether to give away your pet, you should be able to talk one on one to a lawyer. And frankly, we should be negotiating those cases, reasonable accommodation requests, etc. But we don't have the bandwidth. So, we are not opening cases at this stage. We are asking you to come to the webinars or we'll explain the law. You can get a one on one and where to get legal help. Code notices to quit for nuisance, they're usually 3 days. There's not even enough time to do anything about it. Who can move in 3 days? So most of those go into litigation, into the UD process. And again, they have to tell you how it is that you are committing a nuisance. And they have to say that there will be a forfeiture of the lease. And again, we're asking you to come to the webinars where we explain the law, get you a one-on-one, and probably convince you not to call the landlord. Lots of people are accused of nuisance. They want to send a letter, they want to send the explanation, they want to call the landlord. You're just going to end up confessing something that they have to prove. So let's not do that. And then where to get legal help. Again, I especially caution lay advocates and solidarity caseworkers and clients not to try to explain, yes, I was smoking after against the lease after the expiration of the notice, but it was for these reasons. Okay, now you've proven their case. They have a confession where they may not have been able to prove their case. They may not have been able to get the witnesses against you. Okay. Um, Quit no cause. Those are, again, notices that can be served if you don't have rent stabilization protection. They look like this. They have to have this extra, this is all very similar to the others, but they have to have this extra long language about the return of your property. And if they don't, it's a basis for winning this case and making them start again. 60-day notice identical. The 30-day notice is if you've been there less than a year, 60 if you've been there a year or more. Again, they can only do this if you don't have rent control protection. This one doesn't have the return of language. This one doesn't have hardly anything on it, so they can be defective. Come to the webinars where we'll explain the law. You can have a one-on-one if necessary, and we'll tell you where to get legal help. These notices are prohibited during the pandemic. They were prohibited until 9/30/21 by these laws. If you live in LA County, we still have protection until 1/30/21. Although sadly, we have one judge in Lancaster who is saying that this law, that all of this law is preempted by these laws, and therefore that protection is not there. Things are being done to deal with those bad rulings. There is a judge, I believe, in Compton or maybe Norwalk that says that, okay, so we can't kick you out until 1:30, but we can do the trial so the sheriff can execute on February 1st. We think that is also wrong. These laws say that the notices are invalid and cannot be even served during that time period. We're trying to do something about those cases as well. The city of LA has no end to it. The mayor has said our local emergency ends when I say it ends. When the city council votes to say that that it's over, and the mayor signs off on that. If you live in another city, we need to see your city tracker. I know, for instance, that Pasadena also ends when the city council says it ends. The protections in Pasadena are slightly different. It is stronger than LA and stronger than the county ordinance in some ways, but it also has some elements that are weaker. And again, that CDC order no longer exists as of October, as of when it was invalidated by the Supreme Court. Please come to a presentation webinar. I can't stress that enough. I know it's a loss of your day. I know it is time that you don't have, but it'll pay off in the long run. Most of you have my cell phone number. My cell phone number is out there in the world. It has become a useless instrument. It goes off all the time, all the time. And so don't abuse it. Come to the webinars, ask your questions after the webinars, ask your questions during office hours. I do good office hours on Mondays and Wednesdays. As I said earlier, Fridays, I tend to be a little tired. So I also sometimes do want to plan an event on a Friday night. Like last night, we celebrated we had, first of all, our first gathering of my staff. It was, I mean, it is sad to say that some of these people have worked for us since January. I never met them in person because we're doing everything remotely. The paralegals are in the office. The lawyers are working from home in order to minimize contact and have them all very, very socially distanced. So it was the first time, now that they are all vaccinated, that we had a face-to-face meeting. Not meeting, it was a party, it was a celebration, it was a dinner. We played games, it was a lot of fun. So Jalen Bailey, who is with the Pasadena Tenants Union, and I think I've already mentioned her, came in as a tenant in crisis and very disempowered tenant in crisis, and is now a powerhouse in the movement. I came on for 10 minutes, explained that I wasn't going to do counseling that night. And then I know that they were on until really late because I kept coming to check to see if I could turn my computer off, and the conversation was still going. And I swear the little snippets that I eavesdropped on were better than you can get from me, because you're hearing from someone who has overcome the situation about how to address landlord harassment. I think if I can convince Jalen to do that regularly, it should be just what we do on Friday nights. Spend some time identifying real emergencies, get people to come on Saturday, and then not do the one-on-ones with me. The notice to terminate Section 8, that is one where we do retain the cases because we can get rid of it permanently if it's a rent-controlled unit. So if it's a rent-controlled unit with a 90-day notice to terminate Section 8, we will retain it. Because if we explain to the landlord, hey, you can terminate your Section 8, but the rent for this unit is going to be whatever the tenant pays. Right now, the tenant's paying $33 and the government is paying the rest. Do you want a rent-controlled unit at $33? Most landlords will say no, and we can get rid of the effort to invalidate the unit. So imagine these guys have masks and they're in the office, or this lovely lawyer is counseling online. We will open the case. Ellis Act notices, we also will open if the building is organized. We'll assign a lawyer to it if the building organizes. First, because we want to make sure that everybody gets the 1-year extension if they are eligible for the 1-year extension. But also, landlords often bluff. They're really trying to get you to move out voluntarily, and when you won't, they'll say, okay, we'll Ellis the building, but they don't mean it. It is expensive and requires a plan to Ellis a building to take it off the rental housing market. And so we can organize to purchase, we can organize to make sure that tenants get enough money to purchase separately. I organized a building once. There were 6 families, 4 of them were family members. So we organized them to buy another building where they could all live together, and they even one family moved out, didn't want to be part of this um, crazy plan to have these 6 related families buy as I forget what the ownership structure ended up being, but they brought an extra unit to take the little old lady that lived in the 5th unit with them. So we've done lots of creative things to get people into home ownership. And then we will, of course, tell you where to get legal help. But mainly on the LSs, it's to get the group to organize. So it looks more like this, organizing with the help of a lawyer. So the Eviction Defense Network and the Pasadena Tenants Union and the Alliance of Californians for Community Empowerment are part of something called the Stay Housed LA Coalition. We're actually part of something called the Right to Counsel Coalition, which was formed in 2018 with the goal of getting a statutory right to counsel for tenants having problems with their landlords, starting at the notice stage. And we were well on our way pre-pandemic to doing a pilot project in 3 zip codes, the Cadillac model of full representation from the first sign of trouble through resolution of the case, a true right to counsel, statutory. Pandemic hits, city and county say, hey, we don't have the money to do this, and then ultimately are convinced to fund it, but they want us to do it jurisdiction-wide, county-wide for the city, I'm sorry, county-wide for the county, city of LA-wide for the city of LA. And we've also gotten West Hollywood, I'm sorry, not West Hollywood, but Santa Monica and Long Beach to kick in money for their residents. And we formed a website called Stay Housed LA, stayhousedla.org. When you go on there, you can learn more about your rights. You can get that declaration that I showed, that declaration of COVID impact that I showed earlier. You can get a link to all of the laws in the county. I think it has both LA and Ventura County in it. You can find other workshops, and I encourage you to go other workshops. The ones that we promote, Tuesday, Thursday, Saturday at 9 and 1, those are all done by the Eviction Defense Network, but there are 11 legal services programs and 13 community-based organizations that do tenants' rights organizing in this coalition. And I invite you and encourage you to go to the other workshops as well. Please do me a favor. If you hear something there that is different from what I've told you, do not argue with the presenter. It is distracting and it will confuse other tenants. Make notes. Come back and tell me what was different, and I will either explain to you what you misunderstood or find out why we're giving different information, because all the presentations are supposed to provide, like we've had meetings of the lawyers to work out differences of opinion on how the law works and on that preemption issue. And so you should be getting all the same information. So either I'm wrong or they're wrong, and we need to correct that. But come and let me correct it, not in the presence of 40 other tenants that are going to be confused by hearing that some other lawyer is saying something different. And then you can also get legal help. If you click on this, you fill out a questionnaire, you are immediately assigned to a legal services program and a community-based organization, and together they're supposed to work to keep you in your housing. Now, at the beginning of the pandemic, if you got an assignment, you were going to get help. We are now falling grossly behind. We cannot keep up with the volume of requests, and there's no guarantee that we're going to provide you a lawyer. Uh, if you if your case is in the downtown LA court, Pasadena, West Covina, or Compton, but for Compton it has to be an LA resident in the Compton court, and you want us to represent you, you can go to edn.la, fill out the eviction prevention form at the lower right-hand side of the website, and wait for a response. Submit it only once. For a while, we had an error message that's now gone, but sometimes people just, for whatever reason, they get the impression it hasn't been submitted, so they'll keep submitting it. Submit it once. If you do not get a response, come to any Monday or Wednesday, not so much Fridays. Remember, we are trying to avoid that, but Monday and Wednesday, and I will look it up and get you a response right away. We are falling a little behind because the demand is greater than our resources. Everybody else should be going on Stay Housed LA, another website, fill out that questionnaire, and you will be assigned. If you have a digital divide issue, number one, this is tough love, people, fix it. Okay. Saying I can't get on Zoom today is like not being able to mark a telephone number. Okay. If you are not able to get on Zoom, to get on websites, to do research on the internet, you are going to be left behind. Everyone should have a smartphone. You can get one at safelink.com that is government funded. Please work with your children, your niece, your nephew, anyone under 35 years old can teach you how to close that digital divide issue, and it will benefit you tremendously. I'm 62. I grew up in a world where we would send a letter and get a response 2 weeks later. The first time I used a fax machine, the paper came back out. So I sent it again and it came back out. I did it 3 times. I went to tell the person, this isn't working. It just keeps coming back out. Duh. It's sending electronic stuff through. Like, okay. So I get having a digital divide issue. I get not understanding how all this fancy technology works. Pre-pandemic, one of my lawyers, when we got a new program for doing research on the internet, came in to tell me that she was going to teach me how to use it. I'm going to teach you how to do research on the internet. And my response was, Carol, I know how to do research on the internet. You do? Yeah, I send you an email on the internet and you do the research for me. I refuse to learn how to use that program. Now I have to, I refuse to how to learn. Zoom came on just before the pandemic. I'm like, this is crazy. I'm not going to do all these steps. Now I have to do it. Why? Because I work at home and my staff is not here. So I can say, can someone please do this for me on the internet, right? We have to rise above our fears of digital stuff and technology and work with it. If you have an immediate lockout emergency, this is the number that you dial. It rings into a cell phone that is on 24 hours a day. You are going to wake someone up. At 2 o'clock this morning, I got, and this happens way too often, I got a call from someone who had been served a 3-day notice to pay rent or quit. That's not an immediate lockout emergency. Please don't use the lockout hotline for that purpose. You need to come to the webinars and come to office hours. And the other thing about this is at the start of the pandemic, we had lots of volunteers that were, if somebody was being locked out immediately, I could do a rapid response call to action, and 20 people would show up and either stop the landlord from locking you out or put you back in if you could prove to them that you were a tenant. Then the police would come because the landlord calls the police. We are not calling the police. We at the time were not calling the police because they tend to take the landlord's side and they are not helpful to the tenant. And then the advocates would advocate with the police, and we were having huge success rate, more than 99% success rate at stopping illegal lockouts. People have gone back to work, people are burned out. When I activate rapid response, we're not getting that kind of response. I am making efforts to call landlords to get people back in, not very successfully. For most people who have been locked out, it means homelessness and then possibly being able to sue your landlord later for the damages. Again, we cover this more extensively in the 1 o'clock webinar, but it is hard to get lawyers to file those lawsuits. These are the links to the webinars and office hours. This presentation, the link of it will go on the chat, so you'll have that. Now I'm going to show you the documents that that you get once you are in eviction proceedings, the summons. This is what a summons look like. If you take the time to read this, it is a very clear explanation of what you have to do. Unfortunately, it comes with a whole bunch of other papers, and people don't really look at the summons. People will come with a notice to vacate. I said, well, did you read this? Well, no. The print is small. It feels complicated. You don't realize that what you really need to do is just read this little box, which tells you what I've told you. You have 5 days to file an answer with the court. So again, the summons is what starts the process. It gives the court the power to evict you. You're supposed to get it in person. And once you're served, you have 5 working days to answer. But if you get any written document from the court, you should go on stayhousedela.org or edn.la. That's simple, edn.la. No comms, no orgs, nothing else. edn.la. E for eviction, D for defense, N for network, L for Los, A for Angeles, edn.la, and get legal help. Okay. This is the courtesy notice from the court. It says this is a courtesy notice. You have 5 days from when you get that unlawful detainer. And here are some places that you could get from help. All of these are part of the Stay Housed LA coalition. It is probably more efficient for you to just go on Stay Housed LA if you're at this stage. But if you haven't gotten a response, this Shriver project is a faster way to get an answer done, but they may not offer you representation. If you are not offered representation, make sure you are on Stay Housed LA or edn.la if you're in one of our courts. So tenants must be given a summons and complaint. Landlords in person, landlords often lie. That's why the court sends the courtesy copy, and you should go on Stay Housed LA to get connected with legal help. This is another paper that is usually part of that package with the summons and the complaint. This one is directed to anyone who's not named here that wants to defend the case. So if you are not named and you want to come into the case, you have to fill this out. It should not be done lightly. During the pandemic, we did a lot that we probably wouldn't have done pre-pandemic because it was more important to keep people housed. But often you're not named because you're not a tenant and you don't have a right to defend the case. And if that is so, you should just be moving. You'll have about a month. And if the named tenant fights the case, you'll have way more than a month, and you should just be moving because you don't have a right to be there usually. But a lawyer should make that assessment. The complaint tells the court the landlord side of the story. It looks like this. It's 4 pages. It says the titles of all the documents are at the bottom. When you get that thick packet, I ask you to look for, or whoever's counseling you will ask you to look for look for the notice of case assignment, and people can't find it, but it's there. You just have to read page by page until you get to the one that says notice of case assignment. This is what the answer looks like. See answer, page 1 of 2. If I say, send me the complaint, you're looking for the 4 pages that say complaint unlawful detainment. If you've already filed an answer, if everyone could please mute, you're looking for the 2 pages plus any attachment of the answer. This is your side of the story. After you file an answer, maybe there'll be discovery. Eventually, the landlord might send something called a request for entry of default. This is scary. It means they're saying answer not filed. But look here to see who the default is against. If it's against you, even if you filed an answer, we need to get in there and figure it out. We recently recently had a tragedy, frankly, on a case where the tenant had either 2 or 3 prior cases with us. On case 4, she dilly-dallied and didn't get everything to us right away. She wasn't served, but she didn't go immediately to the court to get a copy of the entire file and the registry of actions, which is what we had asked her to do. When she brought it in, she didn't bring the complaint. Without the complaint, we can't answer. We don't know what to answer. It took her a couple of days to do that. She finally did. She brought it in on X day, and the next day we filed her answer. The paralegal checked to make sure that there was no default entered. What had happened is, probably because they were behind schedule, this document hadn't been inputted into the system, and neither had the actual default judgment. We did all kinds of work on this case. We propounded discovery. The other side said nothing. The other side, I think, even requested a trial. So the case is proceeding. We have no reason to believe that there is anything amiss here. She suddenly comes in with a notice to vacate from the sheriff that came by mail, which means that the landlord must have ripped off the one that was posted. The sheriff is supposed to hand you that in person. If you're not home, they post it on the door and send one in the mail. The one in the mail always comes too late for us to do anything about it. So by the time we see it, her notice is already either expired, about to expire. We give notice, but we can't get into court until a point at which she could get locked out in the morning. And sure enough, she got locked out in the morning. So let's not ignore this. Let's see if your name is here. Then we have to look into whether or not there's a problem with your answer. After the answer, many, many steps and lots of opportunities to negotiate. So all of this happens in the process. You might hear your lawyer use the word pleading or motion. On TV, you see the lawyer walking down the hall and sees the judge and says, Your Honor. That does not happen in real life. You cannot talk about the case to the lawyer. To the judge, without the other lawyer present. So you don't just have casual conversations in their chambers or in the hallway. You have to file pleadings in order to get things before the judge, motions in order to get things before the judge. Please watch this YouTube video on motions for summary judgment. There are scary motions that are getting done more and more. The other side basically says, hey, everybody agrees on the facts and we win. They get done very, very quickly, and most of the time we win them, but every once in a while we'll get a judge that will grant one that shouldn't be granted. And so you need to not be caught off guard and know what they are. Discovery is that process of asking for all the evidence that each side has against each other. And then if it's a jury trial, we also have to prepare all of these documents: the statement of the case, the witness list, the exhibit list, the instructions that explain the law to the jury, motions in limine, which is things that we don't want the jury to hear because they're going to be more prejudicial than probative, meaning they have nothing to do with the case and they're going to turn the jury against us. For example, if you are a felon who's gotten out of jail after raping someone, that totally has nothing to do with this case. The jury doesn't get to know that. But if you're a felon who was convicted of fraud, which has to do with the veracity and whether you're an honest person, you can be a rapist and still be honest. But if you lied before and got convicted of fraud, maybe the jury gets to hear about that. But we want to do a motion to maybe convince a judge otherwise because it was so many years ago and now you are a reformed, honest person. That's a motion in limine and then a verdict form. Um, we prepare the witness list and the exhibit list early in the litigation. And during the pandemic, we have gotten a little lax on this because cases were being continued and continued and continued. But we're going back to being really, really strict. You have 5 days to get us your evidence. If you say that on the date of that alleged incident you were at a party at your friend's house, we need the 4 witnesses that are going to come in and say, yeah, no, at that time, that guy was with us. There's no way he did that. If you say that this required notice under the rent stabilization ordinance is not posted, we need you to identify 2, 3, 4 neighbors that are going to come and say, yeah, not posted, or yeah, never been posted, but 2 days ago they put it up. Okay, so we need those witnesses that prove everything we're trying to prove or disprove what they're trying to prove. And we need an exhibit list. And the exhibits are, we need you to bring every stitch of paper that has anything to do with your tenancy. And that includes photographs, videos, texts, emails, in chronological order, not a mush mush. All the proof of payments of your tenancy, if it's rent controlled since the beginning. Sometimes we find illegal rent increases that happened 6 years ago and can win a non-payment of rent case because the notice is demanding too much money because you've been paying 3 cents a month too much for the last X number of years. So every stitch of paper is what we need, and we need it organized, we need it scanned, or you need to bring it to the office so we can photocopy it and scan it. JPEGs, no good. We were being patient with that at the beginning of the pandemic, but people need to learn how to either take it to a Kinko's, get a scanner, or all smartphones can download a scanning app to be able to scan documents instead of photographs. And we need that early. We need it to assess the case. And we also need it because we don't want to be running around like headless chickens as the trial date approaches, trying to get too many cases done. So do it early. If you lose, there are some post-judgment motions that can be done. This is the notice to vacate that the sheriff posts on the door. Don't call and say, I'm being locked out on the 25th. That's just the last date you can be there. So the notice to vacate expires on 2/25/18 is the correct wording. It comes with 3 other pieces of paper. The writ, it's 3 pages, 1 piece of paper, 1 document. It's called a writ of execution. We need all of it. We need this, we need this, and we need the whole thing. People will send us this page, but it has a notice to vacate on top of it. We need the whole thing, and then page 2 and page 3 to see as part of our analysis of whether anything can be done this late in the game. Sometimes that what can be done, this is the pre-judgment claim of right to possession. This is something that you use to get into the litigation. This is the claim of right to possession. There's already a judgment, you have a notice to vacate, but if all of these things are true, you can get a bite at the apple. So you have to not be named in the complaint. You have to have been in the unit before the eviction started. You have to still be there. And this document here, the prejudgment claim, wasn't served when they brought the papers to the other tenants that live there. There is also an exception for tenants that are in foreclosed buildings. So if you're in a foreclosed building, you can get back into the litigation. How is it that we have that law? During the mortgage crisis of 2008, there would be tons and tons of cases where the tenants have already been getting stuff to the landlord about the fact that they're in foreclosure, because all the rip-off services find out and start sending stuff. We could save your home, but you've been giving all that to the landlord. And then you get a summons and complaint, but it's not addressed to you. It's addressed to the landlord. So you give that to the landlord, and the landlord doesn't say to you, you need to file your own answer. And so then you lose because you didn't file an answer. Okay. So if you get any of these papers, any of this, you need to immediately get a lawyer to figure out what to do. Best place to get a lawyer in LA County is stayhousela.org. If you're in a court that Eden represents in downtown LA, Pasadena, West Covina, or Compton, Compton is only for Compton residents. If you're in any of those courts, you can also go directly to edn.la, bottom of the first page of the website, fill out the eviction prevention form. It generates an email to our staff. We will get back to you within 48 hours. If we do not, please come to my office hours so I can handle it. Our office hours have been posted in the chat and also are in the presentation. When the sheriff locks you out, they put this on the door. If you break in with this on the door, it could be prosecuted as either a misdemeanor or a felony. We recommend you don't break in once this has been posted. Again, Right to Counsel Coalition. There are 11 courts in LA County that hear evictions: West Covina, Pasadena, Compton, Long Beach, Norwalk, Mosque, downtown, Lancaster, Van Nuys, Chatsworth, Santa Monica, and Inglewood. And the 11 LSPs, legal services programs in the Right to Counsel Coalition, have divided up these courts. So Eden, for instance, represents in West Covina, Pasadena, Compton, and Compton and Mosque. So we will take people who are eligible for the grant in those courts, and we'll also represent people who are above 80% of median income and not eligible for our grants, and charge them based on ability to pay. So if you're eligible for one of our grants, representation is for free. If you are not, then we will charge based on ability to pay. Theoretically, we also will do that in, where are we? Eden. We'll do it in Santa Monica, Inglewood, and Norwalk. But the reality is we don't have enough lawyers. So we are not opening any cases that are not grant eligible in these courts right now. We can't staff them. Plus, we have to have separate lawyers to do that. Our lawyers are on the grants, and so we have to hire lawyers to do sliding fee, which we will eventually do. We're going to start raising money so that we can pay their salaries for 3 months while tenants are able to pay something. Pre-pandemic, we didn't take grants. We were exclusively a sliding fee scale program, charging between $700 and $2,500 based on ability to pay. At the end of February of 2020, our income plummeted from the $4,500 we need a day to pay all the expenses of a staff the size we had at the time and the rent, etc., from 4,500 to 250 average. So on the 16th of March, I laid everybody off but one person. I raised enough money to keep that person employed. 4 of us volunteered full time until we were able to become part of this grant funded program of the city and the county of Los Angeles. I want to make sure everyone remembers that we may be powerless to prevent injustice, but we must never fail to protest, and that when we fight, we win. That is the end of the presentation.